Okay, so a couple more law stuff. There was a lawsuit about EB5 deauthorization of regional centers. EB5 went and just cut off a bunch of regional centers off the list, and there was a lawsuit, and it was a court approved a summary judgment or something like that. That's as much as I'm going to talk about there. There are some discussions online about third-party signatures. So some lawyers, especially old school lawyers, who've been doing it for 20 years, they'll have a thing in their contract that says, in case I can't get a hold of a client, a lawyer can sign on their behalf. And based on that, they'll just sign, G28s and stuff for the client. That's not legal. The only way you could sign for someone else is if you give a durable power of attorney. Essentially, you have to show that the client's incapacitated and you get a formal court order that allows it. So you're like the person's guardian, essentially. So in that case, so be mindful of stuff. Don't sign. Now, there are things where I think people for bond hearings, they could sign for a G28 because the client's locked up. I've heard people for bond hearings, they'll take a G28 and sign for the client and get it in or something like that, that nuance. But with USCIS, I would not do something like that. But it's a problem. What if the person's locked up and they can't sign the item 130 and G28? How do you deal with that? I'm not sure. I don't deal with those kind of cases. The USCIS policy manual does have a section, a chapter on this of who can sign all that kind of stuff. So be careful, not do some crazy stuff there.